The lawyer has to have a theory of the case. A lot of lawyers in the Sixth Circuit really do not have a theory of the case. They have a lot of potential ideas that they think a Court of Appeals panel might agree with, but they really don't have any one way of thinking about the case which they think is the right way to look at the law. And what that leads to is a brief with one alternative theory after another, really lacking in conviction as to what really ought to be the right approach. Then when you get to oral argument, you have the same problem. As soon as the lawyer meets some resistance on a point, they just continue to switch, and you're left with this sense from the panel as a judge that the lawyer really doesn't have any real conviction about one theory of the case and how to handle it. So the theory of the case is absolutely critical. The second thing that I think is really important for brief writing is coming up with a structure and organization. You know, IRAC is taught to everyone, issue, rule, application, conclusion from probably high school on. Just because it's been taught since you were 15 years old doesn't mean it's a bad idea. In fact, I think it's a great idea. And I'm also a big advocate of dividing up the issues in a case into the positive issues and facts and law that help you, and then at the end of your brief, or the end of a section of the brief, addressing the legal points, the factual points, even the policy points that hurt you. I think that's a lot easier on the brief reader, the judges, and I frankly think, as I thought as an advocate, it was much easier on me when it came to writing the brief. And it's very rare to find a brief I ever wrote or an opinion I ever wrote that isn't divided into that positive and negative approach. So everyone understands IRAC. Something that I think is done quite infrequently, but yet is very effective and done, in my view, by the best advocates, is to divide your brief in what I will call the positive parts of the brief and the negative parts of the briefs. And the way to put together the positive part of the brief is just to take a pen and paper out and think through all of the things that help your side of the case. They're all forms of legal points, so they can be textual points, canons of interpretation, precedential points, cases that help you, facts that help you, equities that help you, even underlying policies. And the best policy usually is, well, if you do this in this case, what about the next case? Those are all slippery slope points. So you get that list together, then you have a hierarchy of arguments. Those are usually pretty self-evident. Text, canons of construction, context, legislative history, precedent, policy type arguments. Then you have your negative arguments. Separate piece of paper, and you write down honestly, don't delude yourself, honestly, what's the other side of the case? If you lost below, you'll have a pretty good sense from the district court opinion. If you won below, you're going to, it'll probably be in the other side's brief. But be honest about it. What are the things? There's probably a bad precedent. There's probably a lurking equity policy point. Maybe there's a textual point. What are those? And then when it comes time to write the brief, you start by using IRAC. You set up your rule. Here's the rule. Here's the way this works. So if it's a sentencing case, here are the rules of procedural reasonableness. And then you do your affirmative, positive side of the case, going through each of the reasons why you should win, without paying any attention to the other side. It's much easier on the reader. I think it's rhetorically quite effective, and it's way easier to write. You've just done your hierarchy. There are 5 reasons the district court should be reversed. First, right through 5. Then the transition comes. The government makes 3 arguments to the contrary, period. They are all unconvincing. It's very easy to write. It's very easy to read. And frankly, do you really think judges get more interested in briefs as they go on? These are not novels where there's a climax as the plot unfolds. I would say most briefs, the judges get less interested as they go along, usually because the relevance of stuff isn't as important. So you will have had the judge's greatest attention on the affirmative side of the case. You're gonna be honest about what the law really is, And you won't have to spend as much time on the negative side of the case because you already will have laid out the rule. At the same time, you won't be hiding the ball from anybody because you will be honestly taking on the other side of the case. And I think it's very effective, it's very easy to follow, and I don't write an opinion without it. I never wrote a brief without it. I don't let my clerks write drafts without it, and I think everybody should be doing it. So I'm a big fan of reading the summary of the argument carefully. I know some judges on my court that in their bench book, that's the one thing reprinted for them. They don't bring the briefs up. They've got reprinted the summary of argument. I'll usually read it the morning of. In practice, I was a big fan of introductions. First thing out of the box. I wanted the first thing the reader to see was something that is a little bit like the issues stated. It's kind of telling the reader quickly at a big picture sense what's going on, what this case is about, and why your side ought to win. Not as legalistic as a summary of argument, but I find both of those things very helpful. First, in orienting me before I start reading, and then second, after I've read, maybe I read the briefs 2 to 3 weeks before argument, coming back and reminding me what this case is about. And if I'm not remembering something, then jumping to that section of the argument. I mean, what you want to do, it seems like you're being redundant. Let's just say you happen to have an introduction, a summary of the argument, statement of issues, and then the full-blown argument. I think some brief writers think, oh, if you're going to do all that, you just take the right sentence from the argument section, put that sentence in the summary of argument, and maybe put that same sentence in the introduction, and even in the issues presented. I couldn't disagree more with that approach. The introduction ought to be written in a way that you could tell a non-lawyer what the case is about, so it's just much less legalistic. The summary of the argument, to be sure, is picking up critical points in the argument section, and I'd say the issues presented is altogether different because it's, what is the issue? So I think the good brief actually keeps coming at it from different angles, even though you may be getting at the same point. First, it should be chronological. People understand stories chronologically most often. That's the way it should work. Materiality is one of the most important words in the law. You've got to figure out what is material, relevant to your theory of the case. So if the focus is on the sentencing hearing, don't burden the reader with all the other stuff about the guilt phase. Here's what happened. He pled guilty to this charge. Done. Now we're on to what happened at sentencing, and then only what happened at sentencing that suggests a mistake. I can't speak for all judges. I can tell you how I read briefs, and I think I speak for a lot of them. It's irresistible in reading a brief to not have some tentative thoughts about who might be right after reading just the statement of facts. So statement of facts is very important in terms of laying out the equities and kind of the underlying premises of the theory of error. So they're absolutely critical. I read them very carefully, no matter what type of case it is. And I think the way it works for the average judge is you've read the statement of facts, you have an initial instinct of, well, nothing seems unusual to me, or something seems wrong. And then, of course, you have to read the argument, the legal section of the brief, and that argument section either allays your concerns, it proves, well, no, what you thought was a problem really isn't, given this precedent, or it allows you to act on that initial reaction to the facts. This was a problem, and we got to do something about it. There was a lot of disturbingly weak advocacy. I don't always think it's because of lack of preparation. I think it's perhaps a lack of understanding as to what argument is about, perhaps a lack of understanding of what's effective. I think a very big reason goes back to my theory of the case. So think of two different types of lawyers. The one type, maybe it's the reason they went into advocacy, the one type seems to think that the lawyer's job is always to rebut what the other side is saying. You never cede any ground. If a court asks a question that seems to hurt your client, then you always oppose it, whether you have a good ground or not. And that is the most frequent type of advocacy we see at the court. It's very frustrating and it borders on useless. And as soon as we realize what's going on, I mean, I may continue to ask questions to keep the argument going, but I've made up my mind this is not a person that's going to help me. Doesn't mean they're going to lose. I've just decided they're not going to help me. Now switch to the advocate that I think does help me, and I think I can speak for most of the court. It's very helpful to the rest of the court. And that's the advocate that realizes the point is not to rebut everything someone else says, whether it's your friend on the other side or the judges in the court. It's to have a theory of the case, and a good theory of the case realizes that there are things you can concede, things that it's reasonable to say, you know, we can win without overturning that precedent. We can win while accepting that what the judge did at this point in the hearing below was appropriate. We can win even if this fact is true. And that's the lawyer who has a great theory of the case. And ideally, that lawyer had that theory of the case at the time they wrote the brief. So we're not switching. It's the same theories there as they come to at argument. But boy, at oral argument, you better know what ground you concede, because that's all we're asking. That's all we're going to do at argument is push the weak parts of your case, and everyone has some weak parts of the case, and therefore it's astonishing to me that all lawyers aren't prepared to cede some ground. That's what you should do. It's reasonable. As an advocate, I looked for opportunities to cede ground. Not just making it up, but just it showed you were reasonable. It showed your side had a reasonableness to it. Again, it's a little bit like the district court who is unlikely to have erred 6 times. It's also likely that your friend on the other side of the case is not wrong in every single respect. The odds are high, even if they're wrong in outcome, they have the kernel of a truth, the kernel of an insight that ought to be respected in the case. And if that's true, respect it, and then show why it still means the outcome comes out your way. This is something I think advocates, it's really useful to know. Most judges at the court are deeply interested in 2 types of things at argument. One type of thing is what the advocate might say in answer to certain questions on both sides of the case. The other thing, sometimes the thing they're most interested in, is what their colleagues, how their colleagues are going to react to the case. And so the good advocate realizes as the argument is unfolding that what's going on is this conversation is going a lot of different directions. It's not just Judge Sutton and appellant. It's Judge Stranch has a question. Judge Stranch is realizing, well, Judge Sutton's question seems to reveal a concern about X. Judge Sutton's realizing Judge Stranch's question reveals a concern about Y. The good advocate tries to find a way to answer those concerns that address both of them and in a way that helps the 2 judges find common ground, right? I mean, we're always interested in finding common ground. No one wants to concur separately, dissent separately. So the good advocate realizes, okay, I'm hearing this, let's take them to this point, because this is a point that would seem to accommodate both or all 3 views. It still happens to be a point that is helpful to my client. So that's a big part of what's going on. So when I say arguments change outcomes, change paths of analysis, they much more often change paths of analysis than outcomes, but they do both. It's partly because of what lawyers are saying, but it's often what the judges are saying, because we talk a little bit about argued cases beforehand, but quite often we haven't talked at all. Learning when to sit down is a really good idea. I've seen cases lost, outcomes changed, because people were unwilling to sit down. You know, sometimes it's very apparent from the nature of the questions, although you have to be careful. A question is not always stating a position. It can be really to get information. It may just be to test something. But it is often apparent if you're appellee, or sometimes as appellant on rebuttal, where the court is, and sometimes the court will be very clear. It'll just say, it'll say, we don't think there's anything else, and some advocates don't even get a sense for that. So I don't understand why advocates don't sometimes get up and say, I'd like to clarify this point, but other than that, the court seems to understand our position, and unless there are other questions, we're comfortable with relying on our briefs. I think there's not only nothing wrong with that, I think the court really appreciates it. Now, I wouldn't do it if there's still some things to be resolved. I think another rookie mistake is just not listening to the argument. You know, the appellant has to start cold because there has been no argument. And so, but if you're appellee or you're the appellant on rebuttal, I would not go to scripted remarks. I would, you should have anticipated this, but I'd go to entering the conversation that's already been had. And there's nothing wrong with starting in by saying, I'd like to start by responding to a question that Judge Kethledge raised, and here's our answer to it. Judges love that. You're not wasting our time. Judge Kethledge is going to be interested in what you say. He obviously asked the question. I'm going to be interested if I'm on that panel, and so is the other panelists, because if Judge Kethledge cares about that issue, we necessarily are want to care about it. The other mistake I would say that appellants make is, starting from scratch. I mean, going through the facts, don't do that. I mean, when I hear people doing that, I'm assuming they're not prepared, that they want to talk about something they know about, and they're afraid to get questions, and to me it's really unbecoming. Go right to the key point. Say, don't say anything. Get right up there. Don't even say you've reserved time. You can tell the clerk, get up there and say, the real point in this case is whether the judge responded to the arguments we made at the sentencing hearing. And here are the 3 reasons she did not. Boom. I mean, we're going to be all ears at that point. Answering the questions, not evading them, that's a classic rookie mistake. Not only answer them, but try to answer them, and if you think someone's frustrated, keep coming back. The court will really respect you for it, whether you answer it or not. The best piece of advice I got was from the Secretary Justice Powell, who said, answer their questions. And there's nothing more helpful and more effective in advocacy than not only answering the questions, but conveying to the court that you want to answer the questions. And sometimes I think it's very effective after you've tried to answer a question. You get a sense, either visual cues or verbal cues, that the court is not comfortable with your answer. Don't be afraid to say, I see the court is not comfortable with that answer. Let me come back to it. I want to make sure I answer your question. I want to make sure I understand what's troubling you.